Good morning. Can everyone hear me okay? I'm Mark Massoud, a professor of politics and legal studies at the University of California in Santa Cruz. I'm glad to be here for this Law and Society Association thematic panel on building the disciplines with law and society. Thanks for being here today. I'd love to get a sense of the people in the audience. How many of you are in law, like law is your primary field? Maybe raise your hand if law, like you're in a law school, law faculty, graduate student studying law. How many of you in the social sciences, like political science, economics? Awesome. And then how many of you in humanities, like history? Okay, so it seems like most people who are here are in law or social sciences and a few in the humanities, and I think that's great. That's fabulous for our purposes, because I organized this panel because I think our field, our interdisciplinary field, and our association are at an inflection point. We've been around for about 2 generations, 60 or so years, and I think this is a moment for us to step back, take stock of where this field has been over the past 2 generations, and where this field might be headed over the next generation, maybe to about 2050. For the next 30 years or so. And I've been in law and society for the past 20 years, and as I think back over the past 60 years, one thing becomes clear, and that is the various disciplines. And here I'm speaking of law, of course, but also anthropology, history, political science, sociology, and others. These disciplines gave birth to law and society as a field, especially here in the United States. It was scholars who were trained in these areas, these disciplinary areas, who really raised up the field of law and society as this space that we know of it today. And as we enter this 3rd generation of scholarship through about 2050, I think it's time for us to take stock, as I said before, of the theories that we offer as a field, as an interdisciplinary field, and the theories that we offer back to the fields that gave birth to this field. So I invited a set of scholars across these disciplines, across career stages, to come here today to share the current and possible future influence of law and society on their fields. I asked them to consider the following sets of questions. First, is your discipline, history, anthropology, political science, sociology, and so on, is your discipline looking to law and society? Is your field even looking to law and society? If it is looking to law and society, what's it looking for? What's law and society providing historically to your discipline? If your field is not looking to law and society, and so what we do in this conference and what we do in our work is kind of adjacent to the fields that many of us work in, why not? Why aren't our fields looking to law and society? And a related inquiry is this. Does law and society provide a new way of theorizing important ideas in the disciplines? A new way of thinking through, for instance, in sociology, thinking through social problems. In anthropology, does law and society offer a new way for anthropologists to think about ethnographic methods, to think about human relationships with one another as societies form, as societies collapse, and so on. And more broadly, the final question I asked our speakers to consider is, what do you think law and society can or even should offer to your fields going into the next generation of scholarship, the next 20 to 30 years through 2050, that can help push the needle forward in their fields, in all of your fields? And I came to this panel not only because I care about law and society, as I said, I've been in this field for about 20 years, but because I also care about disciplines, and I work with a lot of people in a lot of places who care about their disciplines as well. And I wonder, what can we offer to those disciplines? So let me introduce each speaker. They have about 7 minutes each, and I'll ask 1 or 2 provocations after they all speak, and then we'll open it up for discussion so that all of you can join us in this inquiry today. I'll introduce the panelists by their name and their field, or their or their discipline or disciplinary area. I'll let them do any further introductions in terms of integrating their own research or ideas into the question of what law and society offers to their field. Suffice it to say, I've tried my best to represent, to the extent I can, the panoply of cognate fields that we in law and society, I think, are poised to change or maybe are already changing. So we'll proceed in alphabetical order by last name. First, to my far right, to your left, is Asad. Asad is a sociologist and assistant professor of sociology at Stanford University. To my far left is Lynette Chua. Lynette is a legal scholar and professor and vice dean of research at the Faculty of Law at National University of Singapore. To my immediate right, Renee Cramer. Renee is a political scientist, currently provost and dean at Dickinson College. So Renee will be thinking bigger across disciplines. To Renee's right is Jeffrey Omari, who goes by Omari. Omari is trained as an anthropologist, and he is assistant professor of law at Gonzaga University. To my immediate left is Fadzila Yahaya. Fadzila is a historian and assistant professor of history at Yale University. And to Fadzila's left is Emily Zakin. And Emily is a political scientist who studies American politics, associate professor of American politics at Johns Hopkins University. There's one more panelist who was unable to join us, Susan Hirsch. Some of you may know Susan Hirsch. She's an anthropologist, a long-time stalwart in the field of law and society. She's a professor at George Mason University. And Susan is the program officer for law and science at the National Science Foundation. You should know that Susan wanted to be here today. Actually, the NSF told her she can no longer travel to conferences. She's engaged in a national struggle to support law and society research in this country and on behalf of all of us here. I thank Susan for her dedicated service to our interdisciplinary field and also to foundational scientific research in this country, and I'm sorry she couldn't be here today. With that, thank you all of you for being here. Thank you to our panelists, and I will turn it over to Asad.
Good morning. Is this mic on? Good morning, everybody. I'm Asad. It's good to see you all here. Thanks to Mark for organizing us. It's great to be in conversation with everybody. And thank you all for turning out for what I think is going to be just a really fun panel. I'm tasked with starting the conversation about what sociology contributes to the law and society tradition. So I'll talk a little bit about what I think of as the 3 key vantage points that I think sociology brings. And then I'll close with a little bit of commentary on what I think sociology might stand to gain from law and society. At its core, sociology asks us to think relationally. We are trained to attend to interactions, the everyday ways that people make meaning, assert power, and navigate systems. But we're also attuned to how those interactions are structured by institutions, education, healthcare, the labor market, and so on. And these institutions themselves are nested in broader contexts. You have to think about neighborhoods, counties, states, and even time periods. So this layered attention to interactions, institutions, and contexts, I would argue, is central to how I understand what sociology brings to law and society. It enables us to reevaluate legal power, not as something that just exists out there, codified in statutes or enforced in courtrooms, but as something that is filtered through relationships. It's experienced as ordinary people try to apply for a job, enroll a child in school, or access a hospital. These are interactions that occur in specific institutional settings, and they carry different stakes depending on who is involved and what relationships they represent. So a parent and a school administrator interacting is one thing, a worker and an employer, a patient and a provider, or an assistant professor and his many senior colleagues. And these interactions don't float freely. They happen in context. And context can be social, political, historical, and it shapes what's possible or desirable in any given interaction. So a conversation between a Latino immigrant and a teacher in San Diego, California is likely to play out differently than the same conversation in Montgomery, Alabama. And these differences matter. They point to the situated nature of law's power, how it is mediated, enacted, and resisted in particular times and places. So what does all this mean for law and society scholarship, especially as it relates to sociology? One answer, I think, is that we need to take interactions more seriously. We already know that perceptions of legality matter, but it's not just how people perceive the law in some abstracted sense. It's how they observe legal power at work in their interactions, how they measure it through everyday experiences, and how these experiences accumulate into broader understandings of what the law is and what it's for, and perhaps more importantly, who it's for. This is a point I try to develop in my own research. In my book, Engage and Evade, I examine how undocumented immigrants in the United States navigate institutions under the threat of legal sanction. I show that their orientations to the law, whether they engage with institutions like schools and hospitals or avoid them, are shaped by how they interpret the risks of surveillance in those spaces. But those interactions are not fixed. They vary across cities and states. They depend on local immigration enforcement practices, public discourse, and social networks. And these contextual factors, some very visible, others more sinister, harder to detect, influence what people feel like, or influence whether people feel like the law is protective, threatening, or something that they might even be able to ignore strategically. And that matters for how we understand law and society. So this brings me to a second point. I think we need to think more systematically about institutions and their relationship to law and society theory. In sociology, we often treat institutions as the backdrop for social life, places where norms are enforced and identities are formed. But law and society scholarship, I think, would push us to ask what kinds of legal consciousness are shaped in these institutions. How do those institutions enable or constrain legal mobilization? And how do they produce variation in people's experiences of legality across a number of identity markers, race, ethnicity, class, gender, what have you? And finally, I think we need better and more diverse measures of context. So legal scholars, of course, often look to statutes and policies, and sociologists, for their part, might think about these same measures at the county level, at the state level. As an immigration scholar, there's no shortage of papers that looks at state-level measures of immigration policies across the United States and correlates that to any number of outcomes. But we're only beginning to explore more dynamic ways of capturing how people experience context. So what do I mean here? Just because a law is on the books doesn't mean that that law is salient to the people who are subject to it. And so in some of my recent work, I've been using Google Trends data to understand how local information environments shape immigrant health outcomes. So for example, whether mothers in counties with high search interest in immigration enforcement are more likely to give birth to low birth weight babies. Now these digital traces are not perfect, but they offer new avenues for measuring context as it is lived and experienced in ways disconnected from just a policy rollout or some new enforcement action. It helps us capture sort of the everyday interactional processes through which politicians, for example, might stoke the fear of deportation, even though policies may or may not have changed. And so to wrap up, I think the question that started this panel was, are these disciplines looking to law and society? And I think in sociology, we could and should do more. Law and society offers us a way to rethink some of sociology's core concepts, how we theorize institutions, how we understand social problems, and how we conceptualize power and resistance. But perhaps I think more importantly, law and society offers us a sensibility, one that is interdisciplinary, one that is empirically grounded, and one that is theoretically ambitious. It encourages us not just to see the law as a system of rules, but a terrain of struggle, some that applies more to others than some, and a site of meaning-making and a structure of inequality, whether in the United States or in some other world region, like in Israel or Palestine, for example. For those of us in sociology, that's a reminder worth carrying forward. So thank you all very much, and I look forward to the conversation.
Good morning. Unlike many of you at the round table, I only have written notes, so hopefully I can read what I wrote. I think many of the points that my colleagues on this panel are the ones that I also agree, as somebody who was trained in Berkeley in the jurisprudence and social policy program, and then now in the law school in Asia, National University of Singapore. So I thought I would probably should focus on some points that are more unique or more characteristic of somebody who's actually based in the law school versus the social sciences. So first thing I thought I would preface what I want to say about being in the law school and what law and society is, because these two ideas or social groups of academic scholars are actually quite different depending on where you go to or where you are. I always find it very interesting. I have known Mark since 2008. His reference point for law and society's origin is always 1960, the 1960s, right? For 60 years or so. That's the origin of American law and society, and that's the tradition that I was trained in as well. But when I returned to Asia and started to do my own law and society research and started my career there, I realized that actually law and society origins vary around the world. The oldest Law and Society Association was actually founded in 1947 in Japan. And Indonesia, India, and other countries have different origins of law and society, and they are not necessarily social scientists who started to study law using social science methods. Rather, many of them were actually law professors who were unhappy with the limited offerings, the limited intellectual possibilities of doing law doctrinally or through jurisprudence, and they started to look to the social sciences. So I think the difficulty of answering Mark's question, his mandate, his message to us, about how can law and society influence or shape the disciplines. That's one question itself that has to be contextualized, I think. And of course, law schools vary around the world, even in the US. If you're in a tier 1 versus a fourth or third tier law school, their sensibility and their receptiveness to law and society will vary. And that's also the same around the world as well. So whatever I say, I just want to preface that so that we can think about it in a more contextualized way. So I would divide my comments in my effort to answer Mark's questions into two parts. One is actually in response to his question, how can law and society shape the discipline that you come from, which in my case, I suppose is law. But I also want to flip it around. How can law and society learn from the discipline in which that scholar is currently situated, in my case, being law? I thought I will focus on 2 points in part A. What can law and society do to shape the study of law or legal scholarship? I think that being where I am, I've seen how empirical work within the legal academy in various parts of Asia, including where I am, has taken on a higher frequency among the younger scholars. They are more open to doing empirical work. And if you were to look past the most recent 15 years, let's say maybe in the early 2000s, it was virtually unheard of that somebody in my legal academy would be doing empirical work. I don't want to say that this is entirely law and society's influence, but definitely I can see how the presence of somebody like me who has managed to do quite well in terms of doing empirical work and still getting tenure and moving on with her career, they have seen that it's possible to do long-term or major projects using sustained field work to inform their arguments. But I think that one of the pitfalls that I see perhaps legal scholars who are not trained as social scientists or not trained as law and society scholars might run into is the second point that I want to say is that it's about theory building. We as law and society scholars or sociologists or anthropologists have been trained in our research career to build theory, whether it's Massoud level or higher level kind of theorizing from the data. But younger scholars in the legal academy who are using empirical work, they think that it's doing law and society, but that's just only part of the puzzle. The other important bit of the puzzle is what do you do with the data, right? It's not just saying, okay, I categorize the data into, type A, B, and C, and this is my data analysis. I think that next step needs to be theory building. Let's say engaging scholarship on immigration, engaging scholarship on constitutional law or identity. And I think that's something that as a law and society scholar or from the adjacent disciplines can influence our younger colleagues in the legal academy who are venturing out to do empirical work. So these are the 2 points. And actually a side point to that, a third point is, it can also, I think as a law and society scholar, I can see how younger scholars can be influenced to think about the limits of law. Because as a vice dean of research, I also run a doctoral workshop for my law students for PhD students in the law school. And every week somebody presents a chapter from their dissertation. And almost everyone wants to change the law because in the area, whether it's banking law or consumer law, because there's always something wrong that they need to fix. And I'm a law and society scholar, but I'm thinking, wait a minute, have you done empirical work to figure out is that how the law actually operates? So I think that is something that with the interest and the venturing out to do empirical work, that perhaps law and society can influence younger generations of legal scholars in the academy to think about the unintended consequences sometimes of the law and legal reform. I think I'm running out of time, so I'm going to move on to talk about part B of my response, which is to flip it around. I think that there is something that law and society can learn from regular folks who do legal scholarship. I see many people here situated in the law school, so I thought it's worthwhile to talk about it. I've been in job talks where this person is a law and society scholar or sometimes a legal historian. They present a paper and then the dreaded question comes out, but your work or what you just said is very descriptive. The dreaded D word. I think many of you have come across that in the law school. But as we all know, people here in the audience who have done empirical work, it's not just describing anything. We've gone through a whole lot of process in organizing and analyzing the data and presented in a certain way. But to the law professor, you're just, telling me a bunch of facts. So I think, I struggle with this and I don't have an answer. How do I help these younger scholars describe their amazing data analysis but not run into this dreaded D word and just die at the job talk? And I think the way to do that is sometimes it's just wordplay, not say I'm going to describe what I find, but rather this is what I've analyzed and what I found. But at a higher level, it's also to push beyond, these are my findings, categories A, B, C, and D, but to engage in conversation, in theory building, even if it's just micro level kind of theory building about your data. What can we learn from this specific case study or country study about topic of immigration or citizenship? I think that might help us, or our younger colleagues from the law school, avoid the dreaded D word, as I call it. The second one, I think that, and so really this is not about law and society learning from law, but learning from the interactions with regular legal scholars. Second point that I want to make is, I think it's useful for me, having also been trained as in the basic legal education. I have a basic law degree, it's an LLB degree. In the US, the basic law degree is a JD. I'm somebody who is more precise about exactly which legal provision I'm talking about or what I'm critiquing. I realized, and this is something that I do as a matter of just habit, but I realized that it's not always what other scholars do or scholars in the social sciences. For instance, I went to present a paper in geography in my university, and then the first comment that a colleague from geography said, wow, you're very precise about the legal provision, like you're spelling out the provision, like exactly what's wrong with it. And my response is that actually that's exactly what you should be doing. If you are going to be critiquing about the law being hegemonic or it's being discriminatory, we better know how exactly it works through the administrative process or through the court process, rather than, sometimes we see articles where they talk about, oh, this law is discriminatory, but exactly how does it work? And this is where I think legal training actually helps. At what stage? Is it at the point of plea bargaining, or is it at the point where the case is being argued in the court proceedings? I think being precise about the provisions and the regulations that you want to critique are also actually very helpful for law and society scholars, and that's something I think, strangely enough, is what law can, or legal education can train a law and society scholar. So I'll stop there. I'm happy to answer questions later. Thank you.
Lynette and I think similarly, so we'll hope. Hi, thank you all for being here. I have to take my glasses off so I can see my paper, and I won't be able to see you. So I asked myself the question, how can law and society or socio-legal scholarship contribute to the disciplines I come from and reside in? And how do those disciplines potentially contribute to law and society? And I will say, when Mark and I talked about this panel a year ago in Denver, just kind of, this would be a fun thing, this would be a good thing, I was in a very different space. And I think, and I mean that in terms of the present contemporary political moment. And my reflections as I was thinking about being here are a lot around that space that we're currently residing in the United States. So I'm a political scientist, and I have barely ever said that out loud. I really see myself as a constitutive socio-legal scholar. I found Law and Society in 2001, the Miami meeting, maybe 2000, as really a refuge from political science, where I ended up in a PhD program at NYU that was very focused on game theory, which I found to be incredibly decontextualizing and alienating, and understandings of democracy that were predictive based on GDP data and a whole bunch of spreadsheets. And I was one of maybe 2 or 3 people in my cohort who talked to people for their degree. So I'm trained primarily as a comparativist, but my secondary fields were political theory and public law. And I focus on the United States using a comparative lens. And so the other day, January, I was at the Southern Political Science Association meetings. I was invited there to speak on a panel of women in higher ed leadership who are also political scientists. But I went to the keynote because a friend of mine was the president at the time, Elizabeth Oldmixon. And she gave this really beautiful talk about the loss of her faith in the field of American political science, given what she is seeing unfolding. And she did this beautiful kind of, I would have called it law and humanities work, talking about a need to forget what she had learned in grad school about the resiliency of institutions, the durability of the Constitution, the presence of a rule of law, and how process will save us. And I raised my hand and I felt almost bad doing it, but I said, gosh, Elizabeth, you should come to Law and Society, because we have known this for 20 to 30 years. The foundation for me of a socio-legal understanding is that rights are contingent on acting upon them. that the rule of law only exists with a democratic body willing to enforce it, and in fact that the rule of law is malleable. It's not the kind of thing that we can unreflectingly call good. I feel as though at this moment in political science, some of our colleagues might need to hear from us that we have come through that moment in our discipline 10 to 15 years ago, 20 years ago, and made it through. That the feeling of groundlessness that some folks, at least in the subdiscipline of American political science, are feeling related to institutional norms is one that we will disciplinarily live through. And I think that the way Law and Society can further help those people is to say one of the better ways to approach things is comparative. In Elizabeth's keynote, she said, I wonder if part of why I'm feeling this keen loss is that deep within me, deep within my training, was an American exceptionalism that I had not yet interrogated. And I think that a Law and Society tradition does interrogate that understanding of American exceptionalism. So I'm also the editor of the journal Law and Policy, and I really, really appreciate what Lynette and Asad have said about the theory building that we do, those of us in this room who are Law and Society scholars. I often get papers from political scientists who do work on courts, and from sociologists who are also criminologists. And there's this feeling I have where I'm just like, if you could nudge it towards a theory, it would really help. And by that I mean, if you could think in an integrated, holistic, and deeply contextual way about the super cool data that you're showing me, it would help. And I don't think this is about scholars being junior, and I don't think it's a lack of imagination on their part. I think it's a lack of a discipline, sociology or political science, caring about those kinds of deeply contextual, connecting things. The dreaded D word, descriptive. My work has been called descriptive. I say it is interpretive. But I also had to learn. I mean, I've been in this field for a very long time, and I had to listen to my advisors and boosters talk about my work in that way, so that then I could say, I do constitutive sociolegal scholarship with an interpretive method. That's the kind of language that I think we gain at Law and Society because we're able to telescope out. So that's the disciplinary perspective I want to bring. But in the last 5 minutes, I want to talk a little bit about the way I'm using Law and Society scholarship to navigate my current life. And I think it will reflect back to people in this room about where the discipline can go. I'm hopeful. So I am a dean and provost at a small top 50 liberal arts college in the United States, not currently on the list of colleges that are under attack right now. I'm not at Smith, I'm not at Wesleyan, I'm not at Harvard. Our endowment is under $1 billion, thank goodness. We don't rely, it's the only time we've ever been happy, right? Not having a huge endowment. And we don't rely significantly on federal funds. We get about $2 million, 1.8 in federal funding every year. Most of our research is funded by philanthropy, thank goodness. Every day, though, I am dealing with what this administration is doing to higher ed. I'm very, very lucky. My boss, my president, is a former federal judge. He's a Republican, Tom Ridge appointed in Pennsylvania, and speaks with great authority about not bowing. He said on CNN the other day, we don't bow down to tyrants. The principle of academic freedom is that government cannot tell us what to teach or how to teach it. He is a staunch defender of what we do. And he lets me do my job. And my job is to defend academic freedom, to make sure my faculty are safe, and I mean that literally. We have one faculty member who's going through the green card process. She is Palestinian. She writes on Palestine and Black Power. She has family in the Ukraine. We have taken down where her office is located so that if they come, with an administrative warrant, they have to go to legal counsel to find her. Those kinds of things. We have students who were involved in the encampment. We had a 10-day encampment on our campus, and it was handled well. The students were brilliant, but we give them advice about how to navigate when they are going to be traveling abroad and how to wipe their social media and how to do that. We also have lost We lost an NEH that we were able to get philanthropic funding to backstop for a faculty member, first-gen faculty member writing on Black Power in Detroit. And we were able to find a donor to subsidize what she lost with the NEH. But we haven't been able to fill in when we lose our student Vista positions that actually help our local community. And that's the part where Law and Society Scholarship feels important to me, because one of the reasons higher ed is being attacked is that the lack of trust in higher ed by the general public comes for good reason and helps push a narrative that all of these elite people all we do is navel gaze and leech on the economy and hold a bunch of money in reserve and don't help our communities at all. So one of the things I'm trying consistently to do is help solidify and reaffirm our place in our region as democratic practice. Yep. I'll come back to that if there's a question. I want to just close by saying one of the reasons this feels important is for a Law and Society reason. Law and Society as a discipline, which to me is a set of practices, emphasizes interconnection and optimism. I love Law and Society because it is always on the lookout for the counter-hegemonic, anti-institution, undercutting of power ways through things like the present moment. So I am trying to build communities of scholars and communities of leaders where we engage in that kind of counter-hegemonic, anti-institutional set of practices while firmly entrenched at the head of an institution, which is hard to do.
Good morning, everyone. My name is Jeffrey Omari. In his book, Mark defines positionality as the disclosure of how an author's racial, gender, class, or other self-identifications, experiences, and privileges influences their pedagogy and research methods. To become a better translator, I had to learn to appreciate and employ my positionality as both a law professor and an anthropologist. Interestingly, for me, without understanding the theoretical implications of positionality, I had actually written about the topic many years prior in my dissertation. While in grad school, I conducted fieldwork in Brazil, studying issues of digital rights and governance in that country. And my field sites were Rio's favelas, where I got to know residents who were affected by the government's digital policies, and in a law school with the professors who helped draft those same digital policies. But it was my positionality as an African-American lawyer and researcher that guided my translation between those two field sites. My Blackness helped me relate to the favela residents, who were primarily Afro-Brazilians, while my status as an American lawyer provided credibility in the law school. Through employing this positionality, I was able to navigate those disparate environments and speak to the audiences in each. Now, as a social legal scholar who teaches in a law school, I draw from my training as both a lawyer and an anthropologist in my research and pedagogy. And engaging with this community of law and society scholars has aided me in effectively appreciating and applying its theories, like the power of positionality, to my own lived experiences. And it is through leveraging our lived experiences, whether they be self-identifications or professional backgrounds, to the communities that we engage with that can help us become more effective translators. For me, that looks like employing theoretical frameworks from law and society, like the power of positionality, as a bridge between my anthropological and doctrinal worlds. Thank you.
morning, everyone. My discipline of history, particularly in the area of Islamic law, imperial law, and legal history generally, has undergone a significant methodological shift towards law and society approaches in recent decades. In recognition of the fact that law is never separate from economic relations, cultural formations, or expressions of violence, it was integral to how these operated. Since the 1960s, the field has moved beyond treating law as an isolated formal system to recognizing its embeddedness within social contexts. Law and society scholars such as Patricia Ewick and Susan Silby's focus on legal consciousness contributed to the broader cultural turn in historical scholarship that emerged in the 1970s and 1980s, as well as the 1990s, especially in Princeton University, where Clifford Geertz influenced historians such as Robert Dunton and Natalie Zeman Davis. We seek methodological tools to understand how power operates through seemingly neutral legal mechanisms, while bearing in mind that this neutrality remains a powerful facade. In colonial legal history, we look for frameworks that help us comprehend how colonial authority was maintained, not just through visible force, but through documentary practices, administrative procedures, and legal categorizations. The anthropologist Sally Mary, whose work on legal pluralism is particularly trenchant, the coexistence of multiple legal systems within a single social field, has provided historians with crucial analytical frameworks. Other scholars such as Elizabeth Mertz, Carol Greenhouse, and Laila Abu-Lughod continue to show how societies use law to manage social transformation across the world, law as lived experience. So this concept has helped historians understand how indigenous legal systems, colonial law, religious law, and customary practices operated simultaneously in historical contexts. Building on this evolution, law and society approaches provide a fundamentally different way of theorizing historical change, one that understands law as constituting reality itself, rather than merely reflecting or shaping society. After all, law establishes the parameters of visibility and articulation, determining what can be recognized and expressed. Through these mechanisms, law creates worlds. In colonial context, law functions not as an abstract imported system, but as an adaptive medium that both enables and constrains action. It configures environments while being reconfigured by them. Law's effectiveness stems not primarily from overt force, but from its capacity to normalize itself and render its operations unremarkable. Consider the difference between explicit and implicit forms of colonial power. For my second book project, I look at the history of land reclamation in the British Empire, where legal jurisdictions are made concrete. A surveyor designating a shoreline as Crown foreshore appears benign compared to military presence, just as an official document extending authority across oceanic spaces seem less coercive than armed force. This apparent neutrality enhanced the effectiveness of legal mechanisms as procedural rather than coercive. Law and society approach makes explicit how procedural elements such as administrative systems serve as conduits for authority in themselves. A case from Singapore in 1875, which explored in my first book, illustrates this dynamic. A small community of Arab merchants comprising only 50 families in a colony of over 97,000 residents petitioned the British colonial government regarding Islamic marriage and divorce practices. And these religiously conservative merchants were concerned that local religious officials were granting their wives divorces during their travels away from their wives. The response is noteworthy. The British colonial administration, typically reluctant to intervene in religious matters, established a marriage ordinance of 1880 centralizing Islamic religious affairs, recording all marriages and divorces. This was accomplished without violence or mass mobilization, but through strategic engagement with colonial legal structures. Consider also imperial land reclamation projects. Contemporary Hong Kong's waterfront, with its modern infrastructure, obscures the legal processes that transformed coastal zones into fixed property. Invisible are the Chinese merchants who invested in reclamation projects, but were excluded from decision-making regarding the resulting land that emerged. The foreshore, the area between high and low tides, became contested legal territory due to its ambiguous status across the world. In Hong Kong, engineering projects created new land, while judicial decisions established new property rights, since the 1830s when it became a crown colony. The process went beyond creating real estate. It reconfigured sovereign space and established new ontological categories. What makes this legal transformation significant is their eventual invisibility in the landscape. Singapore's current waterfront bears no evident traces of the legal context that determines its use and access. So it's quite an extreme example. This is why law and society approaches offer a new way of theorizing in historical scholarship. They denaturalize what appears given, in a way sensitizing us to change in power relations. They reveal how Western legal concepts such as property and sovereignty, presented as universal phenomena, were specific historical impositions that encountered alternative and introduced alternative legal epistemologies. They challenge the notion that law stands outside society rather than constituted. The theoretical implications are substantial. Law doesn't merely govern identities, spaces, and temporalities, it creates them. How exactly do these approaches provide new theoretical frameworks for historical analysis? In at least three ways. First, they shift our understanding of historical agency by revealing how marginalized subjects strategically navigated legal systems. Second, they reconceptualize power as operating through capillary networks of documentation rather than solely through centralized authority. Third, they reframe how we understand historical transformation itself, not as sudden ruptures, but as gradual reconfigurations of legal categories and relationships that sometimes creep on us surreptitiously. The law and society approach provides an alternative mapping of power, one that traces how authority operates through documentation, how resistance emerges within plural systems, and so on. In conclusion, law and society approaches transform our discipline by changing how we perceive historical change itself. By examining how legal mechanisms constitute reality, these approaches modify the epistemological foundations upon which we recognize transformation. Our scholarly responsibility is to examine the appearance of inevitability and reveal the contingent nature of what seems fixed. Thank you.
Very much for organizing this fascinating panel, and thank my fellow panelists for a really interesting morning. I think many of the themes you've all described you will hear echoed in my talk as well. I'm very honored to be here. I wanted this morning to try on an argument, and I should note this was before I knew we were going to be recorded, but I'm still going to try it. That the insights of law and society were and should remain a kind of North Star for scholars of public law. This is the study of law within political science, as they or we respond to the rise of behaviorism within political science. And in some ways, this is the mirror image of the picture in law schools, I think. So rather than empirical work being kind of marginal and needing a defense, in political science, it's absolutely central, and not just generally empirical work, but actually a set of empirical questions defined in particular by causal questions about what drives political behavior. So political science in the, say, 1980s and 90s becomes really centered on a set of questions about why are political actors doing what they do, what causes political behavior. And when I was in graduate school in the 2000s, the big debate among those who studied law and courts was about whether law constrained judges or whether their behavior was all just a way of achieving particular policy outcomes, the outcomes that they preferred. Could you study the Supreme Court, in other words, the way you studied congressional behavior or voters' behavior, by figuring out what these people really wanted, their policy preferences, and then arraying them on a continuum from conservative to liberal? Could this explain their rulings? And it turned out you could. Republican appointees do make more conservative rulings in general than Democratic ones. And then the judicial behavior literature went on to explore the strategies that justices use with one another and with respect to lower courts to maximize their policy preferences, to get the law as close as possible to the outcomes that judges seem to want. But once we reach this point, of course, law falls away almost entirely. At best, it amounts to a set of weak norms that determine exactly how justices do what they were planning to do anyway. And at worst, it's window dressing, a legitimating veil drawn in front of the real politics of the court. How is it then that people could continue to study law within a political science department? And here, I think, is where the central insights of law and society saved us. The idea is that law is not just a kind of set of words you use to justify things after the fact, but does itself structure and justify our views of the world prior. Law is more than just outputs from courts. It's another kind of clear, obvious insight from law and society, but something that allowed political scientists to start asking a set of new questions, not, well, why did this justice rule in this way, but rather, what role is the court playing in its larger political environment? What is it doing for the political regimes that generate and rely on it? What is it doing for the litigants that look to it? And how, in turn, is it shaped by the larger political world? This is, of course, a way of decentering the Supreme Court, a classic exhortation in law and society, a recognition that there is a much broader politics of law than what's going on in this one judicial body, that the official legal system, organized in a clear hierarchy with the Supreme Court on top, operates in the midst of a crowded legal space in which, and I've borrowed this framework from Sally Engelmary's work on legal pluralism, many systems of ordering and making sense of the world all vie for authority. Once we recognize there are lots of other sites of lawmaking, we in political science, the world of political science, are free to study them. We can study administrative courts, regulatory agencies, street-level bureaucrats, and we can study the way that people make law and legal meaning without ever appealing to the Supreme Court at all. But we can also study the work of recognizably political and yet not recognizably political bodies that aren't part of the government. Work on the NAACP, the ACLU, the Lambda Legal Defense Fund, the Federalist Society, I think falls into this category too. These groups have shaped the meaning of our law and are obviously political. Separately, you could study the way the creation of norms has been central to the working of our political system. So here I'm thinking of the work of my own advisor, Keith Whittington, who wrote a book about the rise of judicial supremacy. Why is it that we think the Supreme Court ought to have the final word on the meaning of the Constitution? Well, this was a socio-legal process that happened over time and is critical to understanding our politics. All right, so not only do I think decentering the court saved the study of law within political science departments, but the second important thing that I think the law and society tradition has done for us is that it lets us see that it lets us understand the mechanisms through which law and politics relate to one another. Let me give you two examples here. One is Michael McCann's book, Rights at Work, which is a kind of classic, and I think many of you probably know it. It was a classic in the field of political science, one that's been central to my own thinking. McCann looked at the pay equity movement of the 1970s and 1980s, and he showed that legal strategies or law played an important role, litigation played an important role, not because of the big wins or policy changes that courts handed to the movement, but because of the way that litigating itself helped to mobilize and energize that movement. I want to end for a second now talking about my own new project, which is very much influenced by this question McCann asks: how is it that law helps fuel movements? And my new project is about what happens when the Supreme Court repudiates a constitutional claim or vision, when it says, that whole idea, we just don't see that here. We reject it wholesale. Now, on one account, you might think, well, the Supreme Court has the final word, it closes the door. This is what actually you hear a lot of political scientists say. They say the Supreme Court is the ultimate arbiter of constitutional meaning, and so it can say yes or no. We, in the law and society tradition, know, of course, that that can't be true. The Supreme Court actually has quite limited power to kill off the constitutional visions with which it disagrees. And then my question is, well, how is it that people keep those constitutional visions alive? And in answering this question, I want to combine a kind of decentering of the federal courts And I do that by looking at states. I'm a federalism person. So not just by looking at state courts, though those, but also by looking at their legislatures and constitutions. And by then asking kind of classic law and society questions about legal consciousness, about the way that those rival lawmaking institutions at the state level shape our sense, or at least a movement sense, of who it is, of their relations to others, of right and wrong, and what is legitimate. I think we need the tools of law and society to answer this question. We need to understand, I promise this was in my notes before, law as a constitutive socio-legal process. A set of legitimating narratives, symbols, and an institution that structures relationships. Law and society already has a big set of theories about how this process of meaning making works. So my own research has emphasized this with state level institutions, and my new stuff on resistance is less developed, and I wanted to give you an example from the book I just published on debtors. And so what happens is that the US Supreme Court in the 19th century says again and again, states cannot relieve debtors. That it violates the Contracts Clause of the US Constitution. It's totally unconstitutional. And it's pretty clear that that is the original meaning of the Contracts Clause. Just, you can't, states aren't allowed to just kind of cancel debts. And yet debtors across the 19th century, in moments of economic crisis, show up and say, we don't care. We don't think it means that. And they push their state legislatures into relieving debts, which the state legislatures do. Actually, in some of their debates, and newspapers pick this up, they're pretty clear that this is probably not going to withstand Supreme Court review, and they just say, like, well, this is what we think it means. This is what our constituents want. And they do this again and again and again until finally, during the Great Depression, the Supreme Court is the one that capitulates. It says, like, okay, I guess some kinds of relief are fine, and the Contracts Clause changes meaning. So I don't know if my discipline as a whole is looking to law and society as a way to move forward, but I do think there is increasing interest in the politics of resistance. This debtor example is a little example of kind of state-level, bottom-up resistance to kind of top-down explanations of what the Constitution means. And in this studying the politics of resistance, my own experience suggests that understanding the way that law legitimates and mobilizes movements will be very valuable to this endeavor. Thanks.
All right, I want to thank the 6 panelists for that rich and remarkable set of comments about what law and society offers, and indeed what the disciplines themselves continue to offer to law and society as a field. So this kind of interplay between what the disciplines are offering to law and society and what law and society is offering back to the disciplines as we think about the next generation of socio-legal scholarship. I want to ask the panelists a couple of questions as we get started, and then we have plenty of time for discussion, so I encourage you, all of you who are here, to think through what questions you would like to ask the panelists, maybe from your own disciplinary perspective, or bridging together various disciplines whose hats you might wear, depending on where you sit at this point in your careers. So the first question I have is, for whoever wants to think about this, for the panelists, what are the challenges you see? The panelists were quite hopeful, I think rightfully, about the spaces where law and society can intervene and has intervened in their fields, what law and society has offered to history, to political science. I think Emily at the end spoke very well about the idea of a politics of resistance. That many of us in law and society have long been interested in resistance, and this has helped in some ways, this and the study of not just the Supreme Court, but other courts, has helped shape or keep the study of law alive in political science. And law and society really filled that gap in political science. So I want to ask, what are some of the challenges that law and society faces as it moves forward? I think, Renee, you touched on this a little bit in terms of contemporary political challenges, at least in this country. I think Lynette touched on this in thinking about the challenges that law and society faces as a global field. I know Lynette has been very active in the development of the Asian Journal of Law and Society, the Law and Society Association, Asian Law and Society Association. Lynette's a past president of that. Is it important that our field does this? Is this a challenge? Is this an opportunity for our field? Is it a fragmentation of the field? And I know the Law and Society Association has been very keen on building up law and society in other contexts, in Brazil, in African contexts, in East Asian and South Asian contexts. Is this a fragmentation of our field, or is this an opportunity? Along lines with that question is, what fields should law and society be looking to? It could be that you're a sociologist and you say, you know what, I think law and society really should be thinking more about history, like we should, or you're a historian and you think law and society needs to be taking economics really more seriously in a way that we haven't in the past. We kind of let go of law and economics research quite a long time ago, and that kind of moved into its own field. But we have Fadzila here saying, you know what, economic relations is kind of the foundation of how we think about and study a lot of the historical documents, including historical legal documents, that we encounter in archives. So that's the first kind of set of questions around the challenges that this field faces in trying to make inroads in the fields that you all work in. The second set of questions is, one thing that I appreciate about law and society is, at least when it began in the United States, notwithstanding the important critique that Lynette mentioned about the fact that it did begin much earlier, and Lynette and I have written about this in the past together, that it did begin much earlier in other parts of the world, so I don't want to lose that context. But focusing for a moment in terms of how it began here in this country, really a lot of people saw law and society not just as a scholarly field, but many people started referring to it as a movement. Law and society was an association, it was a field, but it also was, for a lot of people, a movement. And I wonder if one of the things law and society is offering is not just a movement for all of us to try and make the world a better place, which many of our state leaders are trying to stop us from doing these days, it seems like, but it's a chance for us in our disciplines to be maybe less disciplined. And that's one of the contributions I'm learning from this panel, is that in seeing law and society as a movement, and in working within and also without or outside of or beyond disciplinary spaces, we're encouraging our colleagues to lift up the fences that block our disciplines from one another and either push them down, break them, lift them and move them to a new spot. And maybe that undisciplining is one of the key contributions of law and society, as I heard it from all of these fields. Omari talked about the importance of translation. And translation means sitting, I think in one way it means sitting on those fences between anthropology and law, between sociology and law, between history and law. Being able to sit on the fence, look one way towards anthropology, look another way towards law, to be able to speak law and speak anthropology at the same time, so that people in both of those areas can take the work seriously. And is that part of the movement that we are? So it's not just a kind of movement for justice, which I think is in many ways part of where law and society came from, but it's also a kind of scholarly movement. If we are going to move toward justice, we need to start at home by breaking down the fences between our disciplines so that we can think about how to answer the tough questions about how to establish a more robust rule of law, how to establish a more real economic and social justice in the places we live, work from, and come from, and so on. So I'll leave that there. I'll allow the panelists, if people want to interject for just maybe a minute or two on anything that I've said in terms of trying to wrap up or summarize what came from me from this discussion. And then I'd love, as I said, to open it up to all of you. There are a group of people here on the panel, but all of you we are all here among equals, and so I want to hear your perspectives and voices and questions and comments too from your disciplinary perspectives. There's a reason the universe brought you into this room today, so I want to hear from you as well. But first, let me return it back to the panelists.
We'll move it. You are welcome.
The cord is long enough. We've now solved that problem. Thanks, Mark, for those really wonderful questions to start the conversation. I think one of the things that I grapple with as both a peer reviewer of academic journals, but also as someone who receives many reviews from these same peer-reviewed journals, is I think one of the big challenges is that law and society, or at least the law as people understand it, tends to be somewhat naturalized, sort of as background noise in a lot of sort of pure sociology journals. And so it's really tough, for example, to convince people that the idea that laws exist is not sort of what Law and Society is about. Actually, Law and Society goes a little bit deeper than that to sort of structure how we relate, how people relate to the law, and not in a way that's just saying, oh, okay, well, not to use that little D word that everybody's been using, not just in a way that sort of describes how laws sort of structure people's lives, but really sort of how people resist the law. So on the one hand, I think law tends to be sort of treated as this background variable in a lot of sociological work, and so it's tough sometimes to foreground that importance because people just sort of say, okay, it's the law, but let's move beyond that and think about what that means. And I think the other challenge that I see is actually that some of the big ideas from Law and Society have actually filtered their way into sociology. Legal consciousness being one example. But the phrase legal consciousness, as it's applied in sort of the most basic way in some of the sociology peer reviews I receive, is that they understand legal consciousness as awareness of the law, which, as all of you know, that is incorrect. And so yet you sort of, but the phrase itself is so sticky in some ways that people love to use it. And I think there's this wonderful annual review of Law and Social Science where Susan Silvey sort of talks about the uses, misuses, and abuses of the term legal consciousness. And so I somewhat see that as a challenge of Law and Society, that as our ideas become more mainstream in the disciplines, they also risk co-optation, for lack of a better term. And then I'll just say one brief point on the movement element. You know, I think I like this idea of being undisciplined. I think that Omari's comments about sort of, you know, you write more like a lawyer, or you write more like an anthropologist, I think maybe all of us have received those wonderful accusations previously in our respective disciplines, and I take that as a badge of honor, as I'm sure you do too. But I would say the challenge with that is sort of how do you make yourself legible to a discipline's evaluators, you know, whether, again, that's from a career standpoint, right? Sort of, who is it that can speak to your candidacy as a scholar who is, I'll just use my own phrase, who's an immigration scholar, but an immigration scholar who is active in Law and Society. And so although there are many immigration scholars who are conscious of the law, they are not all Law and Society scholars, right? And so there's this sort of tension, I think, that we deal with from a career standpoint about how do you make yourself legible to the right audiences when it comes time for things like career milestones, tenure, promotion, other kinds of evaluations. And I'd say that's sort of one of the big risks, I'd say, from a vantage point of being undisciplined, that suddenly you become, you know, illegible in some ways to perhaps the mainstream discipline. And I'm not saying that this is happening or it has happened a lot, but it is a risk that I think that many of us might contend with.
I think I'd like to respond to Mark's first question, which was what are the challenges that Law and Society faces as it moves forward? For me, I see Law and Society as a community of scholars that it allows us to be our professional selves. Whether you are an anthropologist or a sociologist or a lawyer, it allows this very interdisciplinary perspective, which in essence provides us with like a type of multiple scholarly identities. And I think that's really important because to have these interdisciplinary perspectives, as I suggested, it's about our positionality. But our professional positionalities are informed by our personal positionalities. And in this climate, as we all know, our personal positionalities, identifications are under attack. And so I see Law and Society as a way of, again, being our professional selves, and in essence as a way and a means of pushing back against some of the attacks that many of our friends and colleagues and allies are feeling right now.
So I would like to say something about the movement question, and I have 2 vignettes and a theory, and I think they can be brief. One is, one of the ways that I am dealing with the present moment is meeting regularly with groups of deans via Zoom, and one of those sets of deans are all law and society scholars, among them Julie Novkov, Aaron Lawrence, John Gould, and we had Song Richardson, who's law and society, former law dean, former college president. We had her guest with us one Zoom call, and she said, look, if it's all going to break, which it will, we have to imagine starting now how to build something better. The other vignette is I've got a wonderful group of faculty who have passed a resolution asking me to instigate a mutual defense fund among small colleges. I would have been that faculty member 10 years ago before I understood how insurance and finance work. Like, I can't do that. I literally cannot do that. I can do 5 of the 7 things they're asking me for. I can't do those 2. And in conversation, one of my favorite faculty members said, look, in extraordinary times, we have to do extraordinary things. We have to imagine a different world. Both of those moments, the thing that flashed in my mind was Boas Santos's piece, Laws, a Map of Misreading, which is one of my favorite things to teach and one of my favorite pieces of socio-legal scholarship, where he writes about these different approaches that we could take to understanding law. He says we could approach it like it's a carnival. We could approach it like we're on a frontier. We could approach it through a Baroque sensibility. And when I used to teach that, my students used to get all excited. They would be like, yes, we can actually form some new, we're at a moment of inflection and we could do it differently. And the last few times I taught it, first Trump presidency, they were like, clearly we have chosen a path and it's neoliberalism and we're not gonna go to a frontier and we're not gonna have a carnival. And it got sad. But I think that maybe potentially things will break, at least within the higher ed space, so profoundly in the next 5 years that it is indeed the job of people like me who hold this understanding, a socio-legal understanding and a position of power, to imagine, maybe not a frontier, because I don't like that metaphor, but a carnival. And I'm hopeful that that becomes a bit of a piece of a movement that law and society is a part of.
So I think that law and society, history is already undisciplining itself when it comes to legal history, in that we borrow so copiously from other disciplines. So, it could be a model moving forward for other disciplines to do likewise. I think that in terms of, so I'm going to speak in 2 scales. One is micro history and the other is infrastructure. So for microhistory, we, unlike other disciplines, I think, lean into description. We revel in it, we love it. And I think that we are due for a return to microhistory, which has gone out of fashion since the early 90s. Natalie Zeman Davis's work, especially the return of Matanguer, she really goes deep into the French historical record, trial transcripts in a French village in medieval times, and really see how a woman was willing to recognize a man who was not, spoiler alert, a man who was not her husband as her husband. So, in that, it's, the drama aside, right, it really tells us about, the gender relations, village relations, village power structures, hierarchies, agricultural units within the village, and so on and so forth. So it's such a rich story based only on one episode in 1 year, in 5 years, across 5 years in a French village. The other thing that history can contribute and also has been influenced by law and society is the notion, the phenomenon of infrastructure, which could only be seen most accurately from a higher level, from a lens that is wide. And in that, it is prime also for us as historians to lean into the humanities even more. In that, we should look at how things such as land, territory are actually constituted. Because as we lean into law and society, we become more legalistic, we become also more institutional. But there is something to be said about living away from that field and looking at how ontologically these things are devised and thought of, considered by people historically. People like Bruno Latour, Michel Caillon, and Jane Bennett. Histories of materialism. Tiffany Latalbo-King, Robin Wall Kimmerer, with their post-colonial, anti-colonial ethos would also help in the study of law and society.
Sorry. I was sort of hoping I would be unable to speak because my thoughts have not cohered. So I was going to blame the microphone cord. But thank you. I guess one thing I've been reflecting on is the difference between the terms interdisciplinary and undisciplined. Because when Mark, when you said undisciplined, because I mentor graduate students, I freaked out. I was like, no, discipline! And what those two, the valence of those terms. So I think interdisciplinary is a nice, safe word that describes much of what we all on this panel have been doing today, which is to say, here's my discipline and the insights from this interdisciplinary project, and we can pull from disciplines, but that the disciplines don't dissolve. And Mark, your invocation of the idea of undisciplining ourselves is really much more radical, I think, like break the not reach across the boundaries and borrow and learn, but just break them down. And a kind of, I think one of the reasons to move in that direction is to say that the boundaries themselves are keeping us from talking and seeing the really important stuff. And certainly in political science, at least in American politics, we've been having that conversation since Trump's first term. Like, we didn't see this coming. A lot of the theories in American politics, like the median voter, parties will move to the middle to appeal to the median voter. It's just like, how do we teach this anymore? And so you could think like, well, what we gotta do is unblinker ourselves and undiscipline. And then I was trying to articulate why I was so upset about that notion. And one reason is surely this idea of being legible to the gatekeepers, that's a real risk. But I think there's some intellectual reason not to give up on disciplines too, which is that they ask different kinds of questions. They value different kinds of insights, and that very plurality may be really valuable. So I often read a lot of the work of legal historians and draw on it, but I recognize that I'm gonna, in the end, value a different kind of insight than the legal historian. Even though we work on the same stuff and value one another's work very highly, I'm taking something different, I'm making a different kind of argument, and I think keeping that around is probably good for the creation of knowledge.
Sorry. I'm going to try to answer Mark's questions, two questions. The first one about the challenges for law and society moving forward. Because I see law and society developments not as one massive movement, but as different streams around the world, I hesitate to talk about a singular challenge. But I think at the individual level, though, and that sort of feeds into the various streams of development of law and society, for law and society scholars based in law schools, the challenge will be when you are a young scholar coming in, that you could struggle to maintain that law and society identity. I think Omari talked a little bit about that, because you've got to teach something that contributes to the core curriculum. You end up teaching employment law, constitutional law, and you end up publishing in the journals that the law school recognizes. I think that's sort of a challenge at the micro level for individuals, and that, of course, at the aggregate, that affects the law and society development in the jurisdiction that you are working in. The other question that I sort of am interested in answering is the one about how Law and Society Association could influence or move Law and Society forward around the world. I think about this from as somebody who is wearing the hat of Global Coordinator for Law and Society Association. Currently, I hesitate to say that Law and Society Association, by that we mean mainly US-based scholarly community, sort of bringing their ideas about doing Law and Society scholarship and sort of building it around the world. I hesitate to do that, but in fact, I want to sort of latch onto what some of you have spoken about the moment here, is that, when I started out doing Law and Society scholarship, and I don't work on the US, I've been told that, you're working on authoritarianism or some small jurisdiction around authoritarianism. It's sort of like the other case, right? Whereas the majority of people I engage with in the community that I was trained in, mainly in the US and Law and Society scholars here, are not working on that other case. But now I think that perhaps is a moment for our American colleagues working on the US to think about the so-called other cases that have been about law and authoritarianism, how that can inform understandings of legal mobilization. Yeah.
All right, thank you to the panelists for those responses. Let me now open it up to folks in the audience, and I'd love to gather maybe 2 or 3 or 4 comments and then send it back to the panelists, and we might be able to do a couple of rounds of that. So I saw a hand in the back, and then up here in the front. Yes, that's you. Yeah.
Hi, my name is Ari. I have a business that is a judicial consulting firm. So I'm independent. I'm here as an independent researcher but also an adjunct of sociology of law. And thank you all for a wonderful setup for more research in various areas that I'm sure many people would agree with me that was very, very explicit. So I'm having here a PowerPoint presentation of my first class in Sociology of Law, and actually it's titled Law and Society. And while I was giving that class, I understood that some of the students were from various disciplines and interests. And incidentally, I covered every area. I was very excited about the sociologists who started, because I was a sociology major before I went to law school. So I kind of talked about sociology, and in my narrative, I explained how sociology was the bedrock of all of the other. It's in this order. And I don't know if you intended to do that, but you arranged the panel in such a way that you are all sandwiched between sociology and law, and that was awesome. Awesome. I would take you as a pickle right there, and the tomatoes and all of that. But beautiful, beautiful, beautiful concept you have here, and I hope this would be every year, and I hope to be a panelist next year. I'll write an abstract for that. So in that, I just kind of picked up from the last speaker. Awesome. And while I was explaining that, I have the conceptual model here, where I said culture. In one of the slides, I asked the students about how culture, anthropologists would understand that, how culture interferes with the social perspectives, how social control interferes with, and how the courts come in to say they're the final, and then we go into the Roe versus Wade and the Jacksons, and all of that, and how the left wing and the right and the political scientists, and how all of that, and it would interest you to know how the students came up with various perspectives representing all of your disciplines. Geography was actually one of them. We don't have anyone. One of the students came up with the issues of geography and how it was interesting to see how ultimately we boiled back to the fact that, and this was the slide I had, that sociology, if I will put myself here, is like the left ventricle. And for those of us who don't know science, like me, I had to do a lot of research. The left ventricle is that part of the heart that beats and connects blood. Without the left ventricle, you are dead. So this is just a tip off for those of you. Tell your wife that she's your left ventricle, she'll just give you anything. Yeah, so sociology is like the next vertical, right? To the rest of, and then law helps come in to give the icing on the cake, and I thought, to say that. And answering the question on the theory, this is the right place where I would, forgive me, I'm not, to say this, that I propounded the theory in my dissertation. It's called Sociojudicialism, and I tried to marry sociology and law. And in that, I would say that I would offer my theory as a solution to that question. Thank you. My book would be tomorrow at 12:45.
Thank you. In the front, and then we'll move up here to the front. Yep.
Yeah. So I'm Leslie Francis from the University of Utah, and I'm from a field not on the panel. I'm both a law professor and a philosophy professor, and I want to thank the panel. It was a fabulous panel. It helped me understand why I'm here. And I think it was Renee's comments that maybe came the closest to this. There's a movement in political philosophy that's been going for a long time called non-ideal theory or partial compliance theory. There's a whole wide range of ways of thinking about and doing that I identify with. And what this panel helped me understand was how you can both theorize, but do so in a way that's contextual, historical, and attuned to the role of injustice where you are. So thanks.
Okay, so my name is Mercy. I'm a PhD in law at Syracuse University. So my major, I focused on disability law because I myself is a disabled person. So I'm very resonant with Professor Chai said, when we were in undergraduate, everyone was so ambitious to say, oh, I want to change the law. And then once we change the law, the society will be better. So when I was in undergraduate in China, I majored in law. I also thought that way. But when I came to the US, and I started curious about, well, even if we have disability law in China, but why I never asked for reasonable accommodations? I just used my prosthetic leg, no matter how difficult it was, I just climbed staircases. But once I came to stay, I realized that, the Disability Resource Center would ask me, hey, Mercy, do you need accessible buses? Then we can pick you up and drop you at the teaching building, and then there's elevators everywhere. As you can see in Chicago and this building, you can see the accessibility. So people who's in wheelchair, they can enter this building. So that's how I started thinking about, is this a matter of law or is it a matter of how our society understand the disability identity and the meaning of being disabled? So that's how I started my law and society journey, because in my law school, and we don't have anyone who worked on that. So I just read all this article by myself, and I started to explore how disabled people, they use the law or not use the law. It turns out it doesn't matter how the law just write in the books. Because so many scholars will say, once we change the disability law in this way, that way, that's the thing they're reading about. But it turns out disabled students, they don't care about the law. They don't even open the book to say what law it is. They have alternative mechanism. They will work on the relationship with authorities and to get a reasonable accommodation they need it, because for some of them, the reasonable accommodation like cap curves, ramps, accessible classroom just indispensable. So, but my question is, so I explore and I realized they just rely the intense relationships with school authority to get accommodation. But my question is, especially for Professor Chai, is how, because my classmates always ask me, okay, cool, you find this mechanism, then showing that, it's nothing about the law. It's about how they work on relationship to get accommodation. But what's your contribution to legal studies? What's your contribution to law? So what's your insights and what's your recommendation for law? So I want to know, Professor Chai and everyone, wonderful panelists, how to understand this type of questions and how to contribute to the studies you're working on.
I think that your challenge is that, is it that most of the time when you write a legal article, and we often see that at the end you are expected to give a list of policy recommendations.
Right.
I think that's quite a standard thing that PhD students or even undergraduate students when they write research papers encounter. I guess there are two ways to deal with this. One is to go along with it and just give some policy recommendations, but you can give some, you can use the law and society edge in the sense that because you have presumably the paper, all the sections of the paper that preceded that had talked about the problems with legal reform or the problems with the current law. So you can use that empirical insight to make better policy recommendations than somebody who didn't do the field work, who imagined that the law needed to be reformed in a certain way. So you can use that as an edge, having done the law and society work. The other is to push back and say that, look, my paper is not about what law ought to be. My paper is to tell you and theorize about what law is and what is wrong currently. And I think that gives you a stronger law and society identity in a sense. So it depends on how you want to navigate that. I tend to do the latter because I don't like doing policy recommendations. So I think it's really up to you. These are two possible options.
Thank you.
We have about 8 minutes remaining, and I think what I'd like to do, there are a lot of hands that are up, and I want to make sure I privilege the audience because the panelists have had so much time to speak, and if we have time, maybe I'll come back to the panelists as well, but I know there are a lot of people in the audience who want to get some words in. So I saw one hand here, Katie over here, and then another hand up. So we'll get those three, and if there's time, we'll come back to the panelists. But I think hopefully the panelists might be willing to stay a few minutes extra if people want to approach and have one-on-one conversations as well before the next panel comes in.
Thank you. I'm Carl Hansen. I work as a law professor at the University of Geneva in Switzerland, just talking about positionality in a law school that is mainly Black Latin law school, I would say, but has a bit of law and society colleagues also. My main identity is in the field of interdisciplinary children's rights studies, childhood studies. That's where I come from. And I wanted to engage with your question about the movement and asking how, well, I think it's at the same time a challenge, how a movement at the one hand, a movement for social justice, where the origins of law and society lies, but at the same time also this movement towards undisciplining, I also like the term post-disciplinarity, so think anew the thought categories we work with, the theories and so on. So the very slow, long-term one. And of course they relate in the sense that if you're busy with social justice struggles, accompanying social movements, then where is the time to work also on the slower work? And how would you think of how this relates? I think it's very contextualized. I can understand that in the US today, while your own social movement is to preserve the thinking space. So, but that's about the movement itself to have that space to think through things on a long term. But the question is also broader, that I can see that these two movements, they exist within the social legal fields, but it's not always easy to see how they relate because, this resource and time is limited. So when we go too much to the social movement ourselves, the social change, then are we also, do we have enough time also to do the more, I would say, epistemological, theoretical? That's where my question is.
So I want to pick up on Lynette's point that maybe American law and society scholars would be more interested in understanding authoritarianism law and movement mobilization by asking, this is a moment globally where there's an enormous sort of readjustment of political and social reality post-COVID and with the rise of the right and other things happening. And this was a fantastic panel that had enormous insights across disciplines. I'm curious what all of you think are the unexplored questions that we should be looking at this particular moment in history. Without having to disclose your next project, because don't take my project, but I'm really interested because it's such a diversity of perspectives and so insightful. So where should we be looking next given the moment we're in historically?
Thank you.
I'll try to be really brief. So I'm also from a discipline that's not up there, though we've got a couple of shout outs as geography. And that this is a home in a way that geography has never been. And that is because of the interdisciplinarity. And it is because of the way that interdisciplinarity and translating across these disciplines challenges you to think differently. And so I guess my question is really, where are you all going from here? Because honestly, I feel like Law and Society as an international project, movement or not, has this unique potential in this moment that the dominance of American sort of pushiness is maybe getting lifted a bit. And as someone said to me earlier this week, maybe we get to see a little bit of the life underneath. And my hope is that my hope for this moment is that all of us Americans can take a moment to realize the American exceptionalism that's baked into almost everything we do and look internationally for next steps. And so as a Law and Society group of scholars, it is both an intellectual project and also bridging that technical legal aspect that actually does wield power with understanding how that functions. So I guess that's all to say. Are you going to have an edited volume?
More to come. We have about 3 minutes remaining. I think I do want to give it back to the panelists if they're willing to take 30 seconds each, and then we can end on time. And then whoever has other questions, by all means, please come forward at the end. Don't be shy. Please come forward. So why don't we go? Should we go in reverse order this way?
To Kitty's point about the moment, what to learn, let me give you a short story about, I was sitting in the board meeting of LSA 2 days ago, and not divulging why we talked about this, but the question was about censorship. And the very typical reaction is that, oh no, we cannot have censorship. But my point wasn't that censorship is good or bad. I think that it's about rather how do you deal with censorship? How do you work around censorship to get to do what you want to do? And I think that is what people who have studied authoritarianism around the world, looking at resistance, have a lot to offer. It's not just saying that we got to take down censorship or whatever is the barrier head on, but also in various ways, including subversion or compliance on the surface, and so on and so forth. So I found that sort of interaction in the board meeting very interesting. Immediate reaction was, no, we cannot censorship. But my point was, I know it's bad, but I'm talking about how you handle it. And that's something that maybe people working on American Law and Society feel could learn.
I think that the way forward is actually that legal geography, as in we should take the physical, natural, geographical world more seriously, materially, as historians, as legal historians.
I love that answer. I was going to say that I think there is a lot of exciting work in comparative legal studies, and Catherine Young is in the audience, whose book I rely on and really enjoy. But this work on kind of rights movements, I think, had been so dominated by American ideas about rights, and that it's been enormously strengthened by looking at rights in a comparative context. I think we should continue in that direction.
The thing that I would love to have time to work on is the relationship between the rise of this new populism and a distrust of expertise written as bureaucracy, and not a legal consciousness. Like, what's the legal consciousness of people who don't like bureaucrats, but rather something deeper around what has happened to institutions post New Deal that has alienated folks from them, and how might we rehabilitate an idea of institution and expertise as important? What would that mean epistemologically, and could that happen through maybe a look at anarchist theory rather than populist theory? I just want to say about undisciplined. I love the idea of being undisciplined, because for me, disciplinarity is a set of practices, and when those practices are so deeply instantiated that we can be boundaryless and playful, then that's what I would hope for our field moving forward. But it is scary.
Thank you. Someone, I'm not sure who, asked about research agendas that speak to some of these topics. So I'll share mine briefly because I think it does speak to many of these issues. Lately, I've been using the Anthropocene as a theoretical tool to examine issues of political disinformation, online speech, and democracy. And recently I did it within a domestic context, but my next piece I'm going to explore the same issues, but within an international context. And again, I think that speaks to a lot of the issues that we're facing at the moment.
Thanks everybody for all those wonderful questions, and I'm super inspired by everybody on this panel. I think for me to sort of get at the two big questions that I think that the last couple of questions posed for us, what are the unexplored questions and how do they relate to sort of the normative movement perhaps that everybody's working towards? And so for me, I think these unexplored questions are also inspired between the balance, or by the balance between theory and the normative. So I mentioned I'm working on a series of articles relating immigration enforcement and health, with particular attention to spatial and temporal contexts. And the reason for that is to try to capture some of this chatter that isn't about law or policy, but about misinformation. So there was a report of an ICE presence on campus at Stanford, and that actually turned out to not be true. But what is the impact of that chatter, right? How do we deal with that chatter? How do we measure that systematically? I'm also working to export some of the ideas from my first book, primarily on immigration enforcement and system avoidance, to Chile, with my colleague Mayra Feddersen, who is a lawyer and a PhD in jurisprudence and social policy from Berkeley. So we're working to sort of interview immigrants to Chile, South American immigrants to Chile, and how they sort of become incorporated or not into the labor market, and whether they mobilize rights and protections in the face of restrictive or accommodating laws. And then finally, and this is sort of perhaps to the, I think to Carl is your name, to Carl's point, I think my next book is going to look at how immigration advocates understand what it means to change the US immigration system, and how are those perceptions structured within legal and political structures that politicians use to demobilize immigration advocates, or at least to distract them from whatever larger issues they're working to confront by saying, hey, here's a new fire to put out. Move away from trying to shut down this immigration detention center. So yeah, thanks everybody. I'll give it back to Mark to close us out.
You got it.
The only thing I'd like to say to close is there will be more to come. This won't be the end of this conversation. So please join me for this moment just to thank our panelists, thank all of you for your time.